Okay, good evening, everyone. Thank you all for coming today. My name is Shannon Dong. I am a planner here at the RDOS, and I will be presenting the public information meeting tonight for the proposed soil removal and deposition bylaw. So to start this meeting, I'm just going to go ahead and get started with a little presentation here. And then after that, I will go ahead and open the floor for any questions. Right. Okay, so as mentioned, this is a public information meeting for the Electoral Area F, soil removal and deposition bylaw, which would apply to the Greater West Bench area. So just before I get into the details of the proposed bylaw and amendments, I'll just go ahead and start off with a little bit of information about public information meetings. So public information meetings are informal in nature. There are no formal minutes that are taken, but we are recording this meeting for reference purposes in the future. If you have any comments that you want to bring forward to the Regional District Board to review at their consideration of first and second reading of the bylaw and the amendments being proposed, you should submit these in writing because I won't be able to take any of this information to the board members. So be sure to include that in an email or a feedback form that you can either drop off in person or mail into our office. So I am the planner on the file here, and sorry, this is a bit of a recycled slide here. So I'm just here to answer any questions that you may have regarding the proposed bylaw. And I do have Jennifer Clark on the line as well, who is from Clark Geoscience, and she was contracted as part of the Greater West Bench Geotechnical Review back in 2021, that report that was created. So she'd be here to answer any technical questions at the end as well. So we might not be able to answer all your questions tonight, but we can certainly follow up with you. I will leave my contact information at the end here, and I'll drop it into the chat box as well. So if you're not able to ask your question tonight, please feel free to reach out to me separately.
Shannon, it's Riley here. On the website, there's a digit missing from the phone number for people to call in. Do you know the phone number for anyone to call in? I've just got a couple of texts.
Ooh, yes, just a second.
I've got 1-833.
Yeah, it's 1-833.
Yep.
311 4101.
4101. Okay, thanks so much.
Yeah, not a problem. So at the end of this presentation, as I mentioned, we will hold a Q&A open. So we'll be taking questions in turn, and to indicate that you want to speak, it kind of differs based on whether you're participating by computer or by phone. So if you are on your computer, just click the participants button at the bottom right corner of your screen. You'll just have to hover your mouse over your name and click the raise hand button. And if you're participating by phone, you'll have to click *3 to raise your hand. Once it's your turn to speak, you'll be unmuted and I'll let you know. And then once you're done, just be sure to click the raise hand button or *3 to take your hand down. So with that taken care of, I'll go ahead and move into some of the details here about the bylaw. So starting with the background, when the regional district adopted the Electoral Area F official community plan back in 2018, one of the policies that we had included as part of the official community plan was that we supported the completion of an updated technical assessment of the geotechnical hazards in the Greater West Bench area, particularly using new technologies that weren't available at the time that the area was last assessed. And so this assessment was completed, as I mentioned, by Clark Geoscience and Okora in fall of 2021. And as it relates to soil-related activities, specifically for excavation and fill placement, the report notes that changing slope geometry through excavation and fill placement can impact slope stability. Placement of fill in sinkholes and/or gullies may lead to future instability and spoiling soil and/or landscape waste into gullies or onto a steep slope can also impact slope stability. So to address these potential impacts, the report recommended that the regional district introduce a soil removal and deposition bylaw in order to regulate, monitor, and limit the removal and deposition of soil through permitting. And they also noted in the report that combined with the hazard mapping, soil removal and deposition activities can be reduced in high hazard areas and documented within the Greater West Bench area. And now in response to this recommendation, the regional district had established the West Bench Soil Removal and Deposition Service back in July 2022. And that was really a prerequisite to introducing the soil removal and deposition bylaw that's being discussed today. So that really gave us the ability to regulate soil removal and deposit activities in this specified area. So this proposed bylaw, the soil removal and deposition bylaw number 2794, would apply to the greater West Bench area. So that includes West Bench, Sage Mesa, Hasula Highlands, and the Westwood properties. And the bylaw would restrict soil removal and deposition activities unless they met specified exemption criteria or are carried out with a permit issued under the bylaw. So before I get too much into the details of the bylaw itself, I did want to provide a bit of a visual reference here, just to show what different amounts of soil can look like, as the bylaw does make reference to soil volume. So this is just a kind of fun representation here, just showing from 1 cubic meter to 15 cubic meters represented in boxes, just shown with some humans here for scale. This is another representation here. I'm showing, containers that can store 15 to 30 cubic meters of soil. And then another representation here showing 1.5 cubic meters to 23 cubic meters shown in vehicles. So I'm showing you all of these different options really because you can see, soil being brought to the properties. You'll see them in the trucks, but when you are thinking of visualizing how much soil you need for a project, you want to take into consideration something like this, where you can see piles of different types of soils or gravel. So moving on then to the details of the bylaw itself, as I mentioned, there are exemptions that are laid out within the soil removal and deposition bylaw, and more specifically, the proposed bylaw wouldn't apply to situations where the soil removal or deposit is being undertaken in relation to public utility works, public parkland, public trails, or publicly dedicated roads, or if it's being undertaken during a state of emergency declaration being in effect, where that soil removal or deposit is necessary to protect life or property from imminent injury or damage that would otherwise likely result from that event or circumstance that's being identified in that state of emergency. Another circumstance that is exempted is when you are relocating soil within the boundaries of your parcel from which that soil originates. If that soil activity is authorized by a mines permit, as that is a separate piece of legislation that regulates those types of activities, or if the soil related activities would not exceed 25 cubic meters being removed from the parcel in any calendar year, or up to 25 cubic meters being deposited on the parcel in a calendar year. So if your proposed soil activity doesn't meet the specified exemptions, the proposed bylaw outlines certain circumstances in which a property owner could apply for a soil permit. This includes a situation where the removal or deposit of soil is being done in relation to the construction of a building or other structure, an access driveway, or the construction of an in-ground pool to the amount of soil that's considered to be necessary for that purpose. You may also be issued a permit for the removal of soil for up to 100 cubic meters per calendar year, and you could be issued a permit for the deposit of up to 100 cubic meters of soil per calendar year. And as the slide mentions, a permit can be issued for a term of 1 year with the allowance of one renewal for up to 6 months. We are proposing as well that these types of permits would be reviewed and issued by staff. So that authority to make a decision on a permit application is being proposed to be delegated to staff. Now, in cases where someone is proposing activities where a permit can't be issued, in other words, where they don't meet those specified criteria that I had mentioned, such as if the proposed soil deposit would exceed 100 cubic meters within a calendar year, an amendment to the soil removal and deposition bylaw would be required. And in this circumstance, the bylaw amendment would require a decision from the board. And similar to what you would see with a rezoning application, this would include public notification and an opportunity for any members of the public who'd be interested would have an interest in this to submit feedback to the board for their consideration. And I do want to make it clear that even if the board were to approve an amendment to the soil removal and deposition bylaw, the property owner who wishes to carry out that activity would still need to obtain a soil permit. So that would come back to staff to review and issue as well. And as part of the permit issuance process, we would be able to impose conditions within these permits, and specifically for the purposes of avoiding any damage to ditches, drains, watercourses, highways, or public utility works, as well as not increasing the likelihood of erosion, landslip, rockfall, subsidence, or instability. We would also be able to impose conditions to avoid the unnecessary removal of trees or other vegetation, and minimize the amount of dirt and debris tracked onto any public highway, as well as limiting nuisances such as noise or dust. And as part of this project, we have also drafted proposed amendments to other bylaws, which would help support and implement the adoption of a soil removal and deposition bylaw. And so one of the bylaws that would be amended is the bylaw notice enforcement bylaw, and the proposed amendments would establish penalties for contraventions of the soil bylaw. So specifically, if someone were to fail to obtain a permit and carry out activities or soil activities on their property, they'd be subject to a $300 fine. Any individuals who fail to comply with a term or condition of a permit could be fined $200. Failure to comply with an order or notice given under the bylaw would also be a fine of $200, and refusal or hindrance of a inspection under the bylaw would result in a fine of $500. So it should be noted that the amendment specifies that each day a new violation of or failure to comply with any provisions of the soil bylaw, if those continue to exist, that would constitute as a separate offense. So for example, if someone were carrying out soil activities that require a permit and a permit wasn't obtained, they could get fined $300 each day until a permit is issued if the activities were to continue. So additionally, in terms of other supporting amendments, we are proposing amendments to the development procedures bylaw. So that would just detail out the application requirements and the processing procedure for both permit applications and bylaw amendment applications. So one thing to note is that in addition to the standard application requirements that you typically see for something like a development permit or a development variance permit, so things like agent authorization forms, certificate of title, site plans, etc., we would require a detailed proposal summary that includes a rationale for the soil use being proposed. We would also expect to see a description of the amount and type of soil that would be deposited or removed, and any anticipated changes in the site elevation, as well as what measures would be taken to address nuisances such as dirt, dust, and noise that result from the soil activities. And importantly, we would require a geotechnical assessment to be provided in relation to the proposed soil activities. Submitted geotechnical assessments would need to be held to the same standards that are required for those assessments made for hillside development permit applications. And another thing to note is that geotechnical assessments are already required for the construction of new buildings and structures in the West Bench. So that's not particularly different there. However, geotechnical assessments would now also be required for other soil related uses, such as bringing soil onto your property for like a driveway or for other purposes that wouldn't ordinarily require getting a building permit. So lastly, if an applicant is applying for a bylaw amendment, we would require a couple of other things as well. One of them being a contaminated site profile, as well as any requirements that the Ministry of Transportation and Infrastructure has for road maintenance and cleanup that are being imposed in relation to the soil use on the property. And then the last supporting amendment that we are proposing is to the fees and charges bylaw, and this is really just to set out application fees. So a permit application fee would be $150. If you need a renewal, we would charge $100 for that. A application to amend the bylaw would be $500, and if it is deemed to be necessary to hold a public information meeting in relation to an amendment bylaw application, that would be an additional $250. So with respect to where the project stands, at this time, the proposed amendments have already been presented to the Planning and Development Committee, and agency referrals have already been sent out. So following this public information meeting, we will be bringing this proposed bylaw and the supporting amendments forward to the Regional District Board for their consideration of first and second reading. While we don't have an exact date just yet, we would expect to bring this forward to the board in February. Now, if the board ultimately adopts the soil bylaw and the supporting amendments, we would also anticipate doing a 12-month review to see what's working and see how well it's working and if any changes are needed, as this is a new bylaw and we haven't had really any experience with this just yet. So it would be really the chance to kind of check in and just see how we're doing. With that being said, I will go ahead and open the floor to any questions. And like I said, if you don't have the chance to speak tonight, or if you just think of any more questions, please feel free to submit an email. I've got my email up here as well as my phone number. I'll also drop that in the chat box just so everyone has it. And as I mentioned, we do have Jennifer Clark on the line who would be able to answer any technical questions regarding the geotechnical impacts of soil removal and deposit, whereas I'm here to answer some questions about the regional district's bylaws or the proposed bylaws and more of that type of information there. So just a quick refresher for anyone who's joined us since I started my presentation. We are taking questions in turn, and if you would like to speak, if you're on your computer, click the participants button at the bottom right-hand corner of the screen, hover your mouse over your name and click the raise hand button, or if you're participating by phone, click *3, and I'll let you know when I've unmuted you and it's your turn to speak. And then once you're done, just make sure to click the raise hand button or to *3 to take your hand down. And thank you so much for listening. All right, so I do see that we have a question from Eva here. And Eva, I've unmuted you, so please go ahead. And Eva, if you are speaking, we're just not picking you up.
Oh, no, I wasn't sure if the mute was off.
Okay, perfect. We can hear you now.
Okay, fine. Two quick questions that you may have covered in the presentation. Thank you for that. I've lived on the bench for going on about 25 years, I think, and I've long been concerned about the filling in of gullies. And because they provide drainage and also very important wildlife habitat. Is that covered by the new bylaw, if that went through?
Yes, if it's on your private property, you would still be subject to any permit requirements. And if you don't meet those requirements, then you would have to get a bylaw amendment. Another additional requirement would be if that portion of your property is within an environmentally sensitive development permit area or a watercourse development permit area. And both of those do require the contracting of a qualified environmental professional in order to carry out those activities. So they're addressed in a couple different ways, not just with the soil bylaw here. So I hope that answers your question.
In a way it does, except that I've seen a number of gullies filled in and never knew whether there actually were permits for that or people just went ahead and did it. And as I say, they're, yeah, that's not very good. Could I ask one other quick question, or is somebody else?
For sure.
Okay. You mentioned something about the soil coming onto properties. Is there a check, or would there be a check on where the soil came from, whether it was, whether there might be things like noxious weed seeds in it, other contaminants?
We would expect a description of, the type of soil that's being brought onto the property. I think you do raise a good point there about the potential to introduce noxious weeds onto the property. I'm not certain if the soil bylaw would cover that, but that's certainly something that we would look into and take into consideration.
Yeah, I think it would be a good idea to have something included in that, because who knows where some of this soil is coming from.
Sure.
Yeah.
And thank you. That was
Thank
a great
you.
question.
Thank you.
Okay. so I do see that Ben Johnson has their hand up, and go ahead, Ben, I've unmuted you.
Can you hear me all right?
Yes.
Great. Thank you very much. Thanks for the presentation. It was very clear. I just had a question around the penalty component of the bylaw. As I understand it, if you exceed the amount that's allowed per year of soil brought onto a site, there's a penalty of $300 per violation. Is that correct? And that can be assessed per day.
Just double checking for you right here. It would be, so if you had a permit that was issued to you to a certain amount, it would be a term of the permit how much you could bring onto your property. So if you exceeded that amount, you would be fined $200 per day.
Okay, and that would be for every day that you're in violation. Is that correct?
Yes, and similar to our zoning bylaws and things like that, we as a rural regional district would not be able to actively go out and monitor and enforce this. So we still do depend on the neighbors in the area to report complaints if you are suspecting that there's an amount of fill or soil that's being brought onto the property that wouldn't be allowed.
Yeah. Okay, thank you. So it's a maximum of $200 per day if they remain in violation of the bylaw. Is that correct?
Yes.
Okay, I guess I'll probably raise this at the public hearing, but my concern is that that's not adequate, that some people will just see it as the cost of doing business, given the great value there is in fill dumping in the region, which I know from experience through my work. So yeah, I guess I'll just raise that at the public hearing. See if there's any opportunities to increase that. Because I do notice the bylaw says up to $10,000, but I guess it's somewhat limited by the conditions that you've raised.
And to be clear, for this bylaw, a public hearing is not a legislative requirement. So with the concerns that you have, I do highly recommend that you submit them in writing if you'd like the board to consider them. So anyone who does have comments, please make sure to write them in that way. Or send them in
Great,
that way.
appreciate the advice. Thank you.
Yeah, thank you, Ben.
Great, thanks.
And if anyone else has any questions, oh, perfect. So I see a Scott Smith has their hand up, and go ahead, Scott.
Hear me all right?
Yep.
Yeah, just to follow up on Eva's initial comment about the material that's coming onto a site, if in fact we're dumping fill. Yeah, on the ALR lands, any filling or removal of soil requires an inspection by a registered professional agrologist. So this would be somebody who has a sense, not so much from the engineering side of it, but from the soil quality side, and would probably be able to make that assessment in terms of the nature of the fill material. Is it loaded with noxious weeds? Are there contaminants in the soil? Things that we might not want, like asphalt and this sort of thing. This would be the role really that a professional agrologist could provide. So maybe I'll submit this in writing, but I would suggest, Shannon, that perhaps in addition to a geotechnical review, in specific cases, it might be a good idea to have an agrologist inspect the material coming onto the site.
Yeah, and thank you for your comment. And I do want to point out that there are no ALR lands within this subject area, but for sure, I can see, the concern about having contaminated soils, enter the areas. That's certainly a concern.
Yeah,
Thank you, Scott.
I'm aware that these are not ALR lands. Just saying from the point of view, sort of from the environmental side of things, that would be the kind of professional you'd want to use. And that expertise is available to you. So just to point that out, that's all. Thank you.
Thank you. Do we have any other questions? Okay, I do see that Anne has her hand up. Anne, go ahead. I've unmuted you.
I'm also concerned about the invasive weeds that we're bringing onto the West Bench. And I think that the invasive weeds coming in are not just on the subject properties, but possibly along all the routes that the trucks are taking. And I strongly support testing the soil that's coming onto the bench. I also have a question about grandfathered sites. In the past with RDOS bylaws, we've always been told that somebody conducting this kind of activity would be allowed to continue. Is that the case with this bylaw?
No, so there is no grandfathering right with respect to this bylaw. So let's say that you have someone who's in the middle of a project and they're bringing some soil onto their property. The moment that bylaw gets adopted, that a permit is required to continue carrying out any soil deposition there. So no, there's no grandfathering.
That's excellent news. Thank you very much. I have one more question, if it's possible to ask that. I've also lived on the bench for a long time, and I always understood that the gullies were not just wildlife corridors, but water corridors. And I'm wondering if the gully filling that's currently in process might be impacting Penticton Indian Band land, and if the PIB has been consulted.
And certainly that's a bit of a complicated question in terms of any downstream impacts there. I unfortunately would not be able to answer that question. I do believe, just a quick second, I'm just going to go ahead and check our referral listing here.
I didn't see it on your screen, but maybe it wasn't a full list.
Just quickly double checking here. And we did reach out to the Penticton Indian Band in regards to the this bylaw, yes. So they were sent a referral.
Okay, thank you.
Mm-hmm.
And the deposition does not include vegetative mulch. It includes only soil and gravel.
It would include any soil related to landscaping. So that is something that is captured by this, yes.
But it doesn't include mulch, vegetative mulch.
Mulch specifically, I am uncertain of. Let me just double check just the bylaw really quick here, getting into the specifics.
So straw, wood chips,
So specifically, it includes peat, but it wouldn't include anything like compost or biosolids that you would normally use as like a fertilizer, a soil amendment or conditioner. So with regards to mulch specifically, I think that's something we would have to double check on our end. But I think that's a really good question that you raised.
Because it's noted in your demonstration of amounts, it introduces some confusion for readers.
Oh, fair enough. I will go ahead and double check that.
Thank you.
I won't be able to get an answer for you tonight, but yeah, if you drop me a message in the chat there, we can certainly reach out to you if you provide us with like an email address or phone number.
Okay, thank you.
Thank you. And I do see that Eva has their hand up. So Eva. I've gone ahead and unmuted you. Go ahead.
Oh, thank you. It just occurred to me, what is involved in the geotechnical assessment in a case of soil deposition?
So as I mentioned, it's quite dense. So you would have to go through and take a look at what our requirements are in the hillside development permit requirements, but I can go ahead and pull it up right now.
Just a quick, just, don't need a particularly detailed account, but just in general, what they would be looking at.
For sure. I mean, first of all, like one of the main things that we want to see is just a statement that the people who are writing this report are qualified to do so. What their standing is with their professional membership, the professional organization that they're certified through. We'd be also looking at cross sections of the area as prior to the development and post development there, as well as a topographic survey. We'd also want an assessment from the professional engineer that is undertaking the assessment that the proposed soil activity would be in line with specified guidelines for landslide assessments for residential developments. If it's the case of a residential development, we'd also want to know the types of potential hazards to the land that are that are proposed for development, as well as any surrounding property. So what potential hazards exist both on the subject property and surrounding properties. We'd also want to know that there won't be any net decrease in overall slope stability resulting from the development that's being proposed, and just a professional opinion from the professional engineer in the event that there is a geotechnical event that occurs, what the extent of the property damage or damage to life and limb that would occur is not likely. So it's really just a confirmation that the proposed activity could be undertaken safely and wouldn't pose a risk to the property itself or any surrounding properties there.
Thank you.
Thank you. I do see that Anne has her hand up again. So Anne, go ahead.
Sorry, I'm having problems taking the hand down. No, I don't have another question.
Okay, not a problem. Thanks, Anne. Do we have any other questions? Okay, I see a hand from John. John, go ahead.
Hello?
Hi, John.
Okay, you can hear me. I couldn't, you almost cut out there. Just a couple of questions here. Having lived in the area for quite a bit, and we've actually had numerous properties where we've had situations where we've moved material as well as other people have been dumping material on our property. So we've kind of been on both sides of such a proposed bylaw. First of all, I think this is a great thing that the RDOS is planning to put in place, because we have had situations where people have purchased a piece of property and an adjacent property owner is watching them dump all sorts of concrete, asphalt, coal, slag, all sorts of crap down the bank and sometimes onto the neighbor's property. So first of all, I think this is a great idea, as that it should be controlled. For not only that reason, but also for environmental reasons too. My question, and then a further comment possibly. My question is this seems to pertain specifically to a property owner. In the situation where a property has a right-of-way across that property, and the dominant tenement of that right-of-way has the right to come in and do work on that right-of-way, I gather they would be held to the same standard and requirement to get a permit for such purposes, and specifically not just the party that holds the right to do something on the property, but they're contractors. Specifically, we've seen where contractors been hired, say, by the Ministry of Transportation Highways to come in and do some work, and there's that contractor, unbeknownst to even the highways, has brought in some undesirable material or done it property or that type of thing. So I just wondered if that is, even if it is, how that might be proposed, and if it can be or proposed to be addressed, and or if it even can be in this bylaw.
Yeah, so it really depends on the nature of the statutory right of way that's going over the property. So if, let's say, that right of way is in relation to a public utility works, right? You have some sort of, let's say, like you have a water main that runs through your property, and there's a statutory right of way over that for any construction and maintenance there. That is something that would be exempted. So we would not see it come through as a soil permit application. However, if it isn't in relation to any public utility works, public parkland, publicly dedicated roads, then it would not be exempted, and we would expect a permit to be applied for and issued in that case.
So that's definitely a concern then for anybody that would have a right of way through there, because that's that actually specifically did happen on not only our property but on other people's properties, and doesn't to me seem fair that a property owner is held to a higher standard than somebody that has a right of way over the property. So I hate to throw a spanner in the works, but that is definitely a possible consideration as to how that could be addressed. And maybe not, because maybe it's a provincial body would outrank the local government anyways. I don't know. And then my other comment or question, I guess it would might be formed as a question more than anything else, is if there are situations where some gullies or some situations where there is a right of way, there might be a drainage pipe going down, or there might be a proposed drain pipe going down, or some other utility infrastructure was going to be put in place. I would like to see that this bylaw doesn't actually impede that being able to be done. Granted, that work should all be done within the environmentally sensitive development permit, water course requirements, and now a soil amendment bylaw or a placement bylaw. As long as all these things don't impede being able to fix a situation that is actually dangerous. Some of these gullies do have, sinkholes and these types of things in them, and if there's in need of a storm drain to go down and control this drainage, I think Jennifer could clarify this, but there is proposal to deal with some of the surface water that has got to come off this bench and get down to lake level, and that there is a necessity to deal with some of this drainage. So there has to be kind of a compromise here that, done right, that those things can still be done. Otherwise, we're going to kind of defeat the purpose of some of these geotechnical issues being addressed.
Sure, and I'll let Jennifer answer, if there's anything she can contribute here. But I will say again, if this does have to do with the public utility work, it would be exempted, so that there wouldn't necessarily be that impediment there with respect to the bylaw. But certainly, I can see what you mean in terms of any works being done within an environmentally sensitive development permit area, and any immediate works not being covered under that exemption. So I would recommend that you put these in writing as well, just so that we're able to have that considered by the board. So thank you, John, and I'll hand it over to Jennifer.
Sure. Hi there. Thanks, John, for your question and comments about the work along right-of-ways and public roadways, and I did bring that up when I saw the draft of the bylaw. Some of those exemptions could also be concerning. I think, to perhaps reassure you, the work done for the public right-of-ways and utilities along gullies, for example, would be done under the supervision of a professional and under the direction such that it is done in a safe manner and considers all those hazards and potential issues with soil. and drainage. So I do agree with you, and I think that also, you know, having an awareness and understanding that work along these right-of-ways is potentially concerning should be included. So whether that's kind of monitored by the province or by the regional district, I'm hoping it'll be captured in some way. So I don't know if that answers your question.
Sorry, am I still on?
Yes.
It's nice to be reassured, but I've seen it happen, and when you actually try to stop it, when there's a time crunch to get something done, once these things get started, it's almost impossible to stop them. The trucks start rolling, and you know, you don't have an opportunity to very often even look at the material because it's getting loaded down there so fast. Certainly not to stop it. So yeah, if somebody is there to address the situation, but very often they're not. It's again, and then the other concern there too is that you want that regulation, you want that control, and it's specifically not usually the holder of the right of way. It's usually a contractor that comes in, and really all of this should be pre-discussed, preset what the expectation is, and that type of thing, rather than it, you know, finding out that day where the material's coming from and that type of thing. You know, usually things are done okay, but you also have situations where you don't even have a right of way there. You have just a property owner who wants to put in their own drainage, and it might be cost prohibitive for them to even try to correct a situation that might benefit them and their neighbors. Again, but I still think it should lean to being regulated and looked after, but everything done in advance of. So all I'm saying is that those right-of-way holders having that exemption is definitely of concern. But yes, I agree with your evaluation that you hope that the higher body will properly address these things in advance and do everything at least to kind of acknowledge that there is this soil placement bylaw in place.
Yeah, the other thing I'll just point out briefly that this soil removal and deposit bylaw is one of the regulatory tools recommended, and there's other ways and mechanisms to reduce risk, and this is sort of a first step.
Yeah, if a balance can be achieved between regulating and making sure it's done right, and yet not impeding something being done, then you've achieved perfection. Hopefully that can be done.
Great.
Thanks.
Thank you, John. Okay, and I do see a hand from Scott. So Scott, I've just gone ahead and unmuted you. Go ahead.
Thanks. Yeah, good discussion. I was just looking at the permit conditions, and there are several things that are listed there, but there's nothing that it would address why you would not issue a permit. And I guess my question is, using the West Bench as a location for the industrial deposition of excavated materials, is that could still go ahead as long as there was all these other things. Make sure there was no erosion, make sure that there's dirt and debris is not tracked onto public highways, but just the notion of this activity. This isn't a landscaping activity, although it may be couched that way, but essentially what we're looking at here is the industrial deposition of excavated material into gullies and depressions on the West Bench. That could still go even with this bylaw. Am I correct in that?
So not necessarily. So in terms of like the scale that you're talking about for soil deposition, anything that exceeds up to 100 cubic meters of soil being deposited on the property, per calendar year would be subject to and would require a amendment to the actual bylaw itself. That being said, that is a decision that does ultimately end up with the board. So they would be in a position to consider a number of different factors, including, the geotechnical assessment, as well as, as it's required, the contaminated sites profile as well, and just really any other site-specific context there. So there is a discretionary feature of the bylaw amendment application for sure.
But conceptually, this could all go ahead as long as there were no contaminated materials or there was no increased risk of erosion.
That's correct. Yes, the board could say yes to it, and a permit could be issued.
Maybe just to reiterate a comment that was made earlier about the hydrology of the site. Often the locations where the filling occurs is in depressions and gullies. Even depressions play an important role in groundwater recharge. So when we fill depressions, we do alter the hydrology of the landscape. I don't really see anything in here that relates to that sort of environmental consideration. There's really nothing in here actually that relates much to the environmental impacts. Would that be something that could be considered?
Yeah, and I think I mentioned this in a comment earlier, but in instances of land that is within a designated environmentally sensitive development permit area, as well as if it's in a designated watercourse development permit area, both of those have, different considerations than a soil permit. So the scope's a bit different there. But certainly if, a property does contain one of those designated areas and soil is being proposed to be put into those areas or being taken out of those areas, that is something that would require a different type of qualified professional biologist typically to comment on in the form of a formal report.
Okay, good. All right. Well, thank you. I think this is certainly a great first step, and I appreciate what you guys have done here.
Thank you. And I see.
Oh, sorry. I was going to pop in there really quick, and I think you just summed it up really well, Scott, that it's a great first step. And all of these comments, do email them in. It's really important. And I've noticed a few other directors online as well. So others are watching this as well. And I think it's just important to share your expertise and your ideas because we do want to hear them at the board. So thanks for that. But I'll go back to you, Shannon, for sure.
Thank you, Dr. Gettins. So I do see that Eva has her hand up, and I'll go ahead and unmute you. Go ahead, Eva.
Thank you. Just your comment about the water courses and environmentally sensitive development permit areas. Did I hear you correctly that earlier on in the talk you said something about, or I guess when I asked the question about gullies, that the gullies are considered water courses?
Not necessarily. So if that's the thing, if it happens to be within a watercourse development permit area, yes. If not, then it wouldn't be covered under the same requirements that would be held to a watercourse development permit. So we wouldn't require a qualified environmental professional to comment on that or a permit to be issued specifically for watercourse development.
Is there a map or anything like that would show where those official watercourse development areas are on the West Bench? I asked that because of Scott's comment, and we've all seen a number of gullies in the last number of years filled in or otherwise altered, and whether they're official or not, they are all drainage of one kind or another, and as I say, also very important wildlife habitat.
Yeah, so we do have a if you go onto our website under regional bylaws, you'll be able to see the environmentally sensitive development permit areas and watercourse development permit areas as designated under the bylaws. You could also use our internal mapping system that you can find on our website as well to check where those are. I'm just going to try to pull them up right now,
And
just for a quick reference here.
what's the water one called? Water course and
It's a watercourse development permit.
so the maps are on there.
And I'm just pulling them up on the side here so that I can just grab a quick reference for you. So this is the official mapping here from our watercourse development permit areas as designated under the official community plan bylaw. As you can see, it is fairly limited in terms of which areas are designated as a watercourse development permit area. Aside from that, you'll see here in pink, those are the areas that would require an environmentally sensitive development permit to be issued for soil alteration, so bringing any soil on the property or off the property. Those would be held to the requirement of having an environmental professional submit a report on that.
And I assume that map that you just you had before with all the blue lines are the water course.
Yes, exactly.
Yeah. Okay.
And did you have any other questions that I could answer?
Oh, just one quick one. Does the regional district monitor those particular areas in any way to ensure that they're not being affected by activities?
So yeah, as I mentioned earlier, with just being in a regional district, a rural regional district, we don't have really like an active enforcement ability. So we aren't able to have bylaw enforcement officers, go out constantly driving around to pick up these details, unfortunately, right?
No.
But we would rely on any complaints to come in from any neighboring property owners, in cases where you do suspect that there is a contravention there of the soil bylaw.
Yeah, I mean, I appreciate the regional district can't have bylaw officers running around all the time, but I don't know, maybe it needs some more public education, because I suspect that the vast majority of people have no idea, that even that ESDPAs exist, but certainly not watercourse development areas, and certainly not where they are or where to see the map. So, you might see your neighbor doing something you didn't really think was quite right, but there would be nothing necessarily to send you to a map to say, oh, that's this kind of a development area and it needs to have a permit. So maybe some public education about that might be useful. I know this is outside the scope of the bylaw, but
Oh no, for sure. A great comment though. Definitely. That's definitely one tough thing, right?
Yeah.
So
yeah.
I appreciate that.
Yeah.
Thank you, Eva. I do see a hand from Denise. Denise, go ahead.
Hello, it's Denise, who I think you've just unmuted me. I'd like to pick up on the comment that Scott made, and that is about the industrial scale of some of the dumping that we have seen recently, particularly in my neighbourhood, which is just, I'm just east of Duchess Drive. And I think this soil bylaw is an excellent idea, but I'm just wondering if it's getting at the issue of industrial activity, because it's not just the dumping of the soil, but it is the nuisance of having trucks, gravel trucks, basically moving past your house once every 10 minutes. It seems to me that the West Bench isn't a designated industrial area. And so somehow or another, we have to capture this issue of industrial activity in a non-industrial area, which may not be quite met by the bylaw that you're proposing.
I think you do raise a great point there. I mean, West Bench itself is predominantly a rural residential area. So those are the types of uses I think, that folks who live out there expect to see. So certainly that is something that, I'll flag here on my end. But definitely please write in if you would like the board to consider that as well.
Thank you.
Thank you, Denise.
Shannon, just on that, I just wanted to ask you about that a bit further because home occupation is allowed in Greater West Bench, but industrial occupation is not allowed in West Bench. And there are some rules within our zoning. So West Bench does have its own zoning. It's in small holdings 5 zoning. And so home occupation can involve storage of outdoor materials, vehicles and equipment associated with the contractor, trade, or mobile service. But I wonder if that's, rather than trying to think one bylaw can do it all, maybe we need to look at that zoning as well to address some of this, because I hear what Denise is saying. So I just wanted to point that out as well, that home industry is not allowed or permitted in West Bench, but I'm wondering if we need to address that in the whole zoning and not just the soil deposition bylaw. If there's 2 ways of kind of approaching it and catching two different concerns.
And yeah, that would be a project separate from this one. But yeah, you raise a great point about the home industry not being permitted. I mean, with respect to, home occupation, there are vehicle limitations in terms of what you can have out there. So you can't have a vehicle that exceeds anywhere over 1,000 kilograms in vehicle weight. So that in a sense captures some of the issue, but it doesn't necessarily, cut out the vehicle traffic and noise coming from industrial trucks for sure.
Just as a follow of that, Shannon, and just hearing from the citizens, it's been such a great discussion, and I'm so thankful that you guys are all on here tonight. Is there a way to have, can we as a regional district have 2 separate fines? Can we have a fine for residents and then a fine for companies? Is there any bylaws that have different tiers? Because what we're always trying to do in a bylaw is to make sure it works for everybody, right? So that if the citizen does something by an error, that we're not going to add any undue hardship on it. And I think what we're all trying to do is address that ongoing larger industrial, what a lot of people have been dealing with. Do you know if any bylaws have a 2-tiered fine or fees? Because it seems unfair to ask somebody to pay the same amount to bring in some soil for to level their yard and make a garden, and then sort of what Mr. Johnson was saying about the cost of doing business. Do you know anything about that, or we can talk about it further elsewhere too? I was just curious.
Yeah, no, that's a great point. It's out of the scope of what I would really know. It's something that I probably have to double check with bylaw enforcement to see, how they would be enforcing against that. But, as it stands, I think with the way that the current proposed amendment to the bylaw, notice enforcement bylaw, is worded, it would be held the same to, individuals or companies. So yeah, something to double check for sure. So I'm just taking notes here. Okay, and I see a hand up from Eva, and I'll just go ahead and unmute you. Go ahead, Eva.
Yeah, just following on what you were saying there, Riley. I'm not exactly sure how to put this, but if there is if a resident on the West Bench, for example, wanted to have soil deposition, is there an obligation on the part of the company that is contracted to do the work to understand the bylaw, understand the terms of the permit as well as the owner? I don't know if that it relates to anything that Denise was saying, because I know that's that's a serious issue about the trucks and the noise, but I wonder if there is an equal obligation for the people doing the work to understand the terms as well. as the
Yeah.
owner.
I mean, like there's certainly a hope that, the owner would have been in contact with the contractor gets in contact with us prior to works taking place. However, really the property owner would be held liable in that case, should a contravention occur, right? So any fines would be applied to that property owner as opposed to the contractor. And I think this kind of speaks to that same, education piece. And it's something that could come in time, with contractors that work regularly in the West Bench. Yeah, I hope that answers your question.
Yeah, I wasn't exactly sure. I guess I was partly wondering if this question, what you were saying, Riley, about having a two-tiered system, whether, say, in the case of these trucks, if the company could be held liable for a nuisance factor there, or would the resident still be liable for that? I don't know. I mean, I'm just sort of floating a balloon.
You know what? Those are really interesting questions. And I know I'll be thinking about this for a bit. So if you have any of those kind of questions or ideas, just shoot them over to Shannon and I so we can kind of keep working on this. Because I don't know. We need to kind of keep looking into that, Eva. But I hear what you're saying, but I don't know the answer yet.
Yeah.
Thank you, Eva.
Thanks.
And I've got a question here from Denise. Denise, go ahead.
Yes, and just following up on this issue. You mentioned that there is a potential limit within the bylaw of 100 cubic meters. Would you be able to translate that into the number of double or tandem dump truck loads that might be?
So it's a bit difficult to get that kind of precise here. So I'll just put up this screen on the side here. So this just shows kind of an estimate, right, of, it doesn't show 100 cubic meters, but up to 23 cubic meters here. But I think it's really important to point out that dump trucks are loaded based on weight, not necessarily volume. No. So there would be some variance here with respect to, what 100 cubic meters would look like, right? So yeah, unfortunately, I don't know if I have any other visual representation that I can show.
No, but this is great because what it indicates to us is that there would be relatively few dump trucks required to make up the 100 cubic meters.
Precisely.
And so if you have 10 dump trucks a day coming, which is not uncommon in this area, then, they would exceed their limit within one day. This is, I think, something that would be useful for residents so that they can say, look, this is way beyond what we think should be happening here. Who do we go to make a complaint to? How do we try and stop this activity?
Mm-hmm. And that's a great point for sure. Because yes, I mean, when it comes down to enforcement of, this type of activity, it is hard to gauge, and that's kind of why I tried to provide a bit of a visual there, just because, these numbers are very, like, for people who don't work with soil that often, you can't, have this visual representation just come up in your mind, like this is what 23 cubic meters looks like, right?
Exactly.
So
Yeah.
for sure.
Okay, thank you. I'm sorry, you may have shown that in your earlier presentation, but I missed it. So I'm perhaps asking for something to be repeated, but I think that's very useful.
Not a problem. Thanks, Denise.
Shannon, are you going to post your presentation online?
Yes. So we'll go ahead and post the presentation online. So both the PowerPoint, and I can also upload the recording as well, just so anyone can come back to it. We're just after 8 o'clock here. I'm happy to take any last straggler questions, but just so we're not keeping everyone too long, let me just quickly, I'll drop my information before people start signing off here.
And just while you're doing that, Shannon, thank you so much, everybody. Again, it's so useful to have so many good brains looking at this and taking a good look and coming up with good ideas and questions and everything. So please just keep shooting the information and the questions our way, and we will keep working on this for sure. And then you're thinking, Shannon, that we should be able to get this to the board in the first or second meeting in February?
Yeah, I think the second meeting more likely, just timing wise. But yes, I'm hopeful that we can get that right up to the board by then.
Okay. And if you could, would you mind, Shannon, tomorrow, if you've got time, or even like Monday, just to look in to see if there's a way of doing different types of fees and depending if it's a resident or a commercial business. I'm curious to learn a little bit more about that.
For sure, yeah, I can go ahead and check in with our bylaw enforcement staff on that.
Thank you.
Yeah, thank you. One more hand here. So Eva, go ahead.
Oh, just quick question, letters. To whom should we address them? Should we send them to you, Shannon, or how should we do that?
Yes, so you can send letters to my email. I mean, if you want to send it in like the format of an email, that's totally fine. If you want to write a letter or type up a letter and then have that like as a separate attachment in email, that's also fine.
Okay.
I know some people still prefer to bring in their feedback forms by the office, or you can do it by letter if that's easier for you. If you're not currently in the area but you're tuning into this meeting here, you can definitely mail it in too. So we're very flexible with it as long as it comes in writing and before the board considers the bylaw, then yeah, we'd be able to bring that forward. So yeah, thank you for clarifying that.
Yeah. So what's the deadline then? We should get anything in to you?
Well, at this time, if we're able to get this to the second February meeting, the deadline would be, I'm just double checking my calendar here, February 9th.
Okay. Oops. Thank you.
Yeah, thank you. And I do see that we have a number of comments that I just haven't gotten a chance to address here in the chat. If I haven't gotten a chance to get to you, please send me an email or give me a phone call, or you can just leave your email or phone number with me just in the chat as well. So I think we've heard a lot of really good comments today, as well as in the chat box here, I have seen quite a number of comments come in through there. So just a reminder again to, if you want to have these comments considered by the board, please do put them in writing outside of this meeting.
Thank you so much, Shannon and Jennifer and Ben. That was really great. And thank you for everybody for attending. Again, always open to hearing more from you. So please keep in touch, stay in touch.
Yeah, thank you everyone for coming. And I do see that we have no more hands, so I hope everyone has a good night. Yeah, I will just stay on briefly just in case anyone wants to drop their contact information in that chat box there, and I will go ahead and take that down. So again, thank you everyone, I appreciate it.
I didn't see this. Oh, I'm on mute. I didn't see this first question here about why are we allowing gullies to be filled? And I think that's such an interesting question because we're not really allowing it. It's just one of those things we've never had a law against because you know what I mean? It's one of those things where you just because you can doesn't mean you should.
Exactly.
And
it's just a matter of not having the tools to really enforce against it.
yeah, and it was a really interesting process to go with the community because it was so frustrating for people when somebody saw something, when we all saw something that people were doing that was wrong and we couldn't do anything about it. And that was really frustrating for some. So it was It's a very good dialogue to have for sure. So I think we're going to get some great feedback, Shannon. So thanks again, everybody. It was really well done.
Yeah, not a problem. And I was really happy to see the amount of people who came out for this. So that was great.
Me too. That was fantastic. So, and I have no doubt I'll hear some great ideas and more feedback too. So I appreciate it so much, you guys. Thank you so much.
Thank you.
Bye.
Thank
Bye,
you, Shannon.
Jennifer.
Great
Thank you,
job.
Jennifer. Thank you.
Bye-bye.
All right. Have a good night, everyone.
And welcome, Ben. I know you're new. I've just heard about you. So welcome aboard. Bye.